This is your Diamond Insight of Milingo Lungu'S $24 million forfeiture to the state. The country is awash with news of former Konkola Copper Mines KCM provisional liquidator Milingo Lungu'S forfeiture of $24 million United States dollars to the state. The said money that Mr. Lungu is said to have forfeited to the state is deemed to be proceeds of crime, contrary to Section 71 of the Forfeitures and Proceeds of Crime Act Number 19 of 2010. The Director of Prosecutions, Gilbert Piri, made an application for a non-conviction-based consent forfeiture order of tenanted properties. Of this amount, 7 million kwacha was held at Mr. Milingo Lungu'S FNB account, and of the 7 million kwacha in his Stanbic account, 10 million kwacha held at Absa Bank. While we are not privy to the reasons of a non-conviction deal, the DPP based his arguments on 4 legal provisions, which include sections 29, 30 and 31 of the Forfeiture of Proceeds of Crime Act Number 19 of 2010. The Act in these sections provides for the confiscation of proceeds of crime, provide for the deprivation of any person of any proceeds, benefit or property derived from the commission of any serious offences, facilitate the tracing of any proceeds, benefits and property derived from the commission of any serious offence, and provides for the domestication of the United Nations Convention Against Corruption. Also cited in the consent applications are sections 272 and 278 of the Penal Code Chapter 87 of the Laws of Zambia, and we quote, that any person who steals anything capable of being stolen is guilty of the felony term theft, and unless owing to the circumstance of the theft of the nature of the things being stolen, some other punishment is provided, is liable to imprisonment for 5 years. End of quote. Section 278 says if the offender is a clerk or servant and the thing stolen is a property of his employer or came into possession of the offender on account of his employer, he is liable to imprisonment for 7 years. End of quote. Another provision is Section 7 of the Prohibitions of Money Laundering Act, which we quote, "A person who engages in money laundering shall be guilty of an offence and shall be liable upon conviction to a fine not exceeding 170,000 penalty units or to imprisonment for a term exceeding 10 years or both." End of quote. The question for many Zambians is why has government settled for a consent judgment and not commenced criminal proceedings against Mr. Milingo Lungu if indeed he was to be found guilty or was deemed guilty of a criminal offence. We remember clearly that early in 2023, President Hakainde Hichilema, addressing a press conference in State House, denied at any time meeting with Mr. Milingo Lungu, and that government was through the Attorney General's office or through the DPP striking any deal with Mr. Milingo Lungu. We can only assume for now that the consent judgment simply means that the DPP through the state have struck a deal with Mr. Milingo Lungu, who through this consent judgment is indeed a first interested party, while Konkola Copper Mines is second interested party. Only the two legal teams know the reasons as to why this matter has not been taken to court for trial, because grounds may indeed be that the state does not have enough evidence to convict Mr. Lungu, or indeed if the matter was taken to trial, some state secrets or anything that they wouldn't want the public to come to know is what they are hiding. This leaves room for one to conclude the $24 million forfeiture to the state by former liquidator Milingo Lungu may be a slap in the face in the fight against corruption. The UPND and New Dawn government say they fight and abhor corruption. We hold the view that failure to take corrupt people to prison is failure to fight corruption, as there is no punishment when property or money is forfeited or taken back. We saw this in the case of Faith Musonda, and the UPND, while in the opposition, did talk against this when it happened in the famous 58 Houses case, where we ask, is the corruption fight going?